Hello, everybody, and welcome back to another episode of SEC Roundup. My name is Nick Morgan. I'm with the Investor Choice Advocates Network and the co-host of today's SEC Roundup. Joining me as our guest co-host is Art Zwickel. Art is a partner at Paul Hastings in the Private Funds and Capital Practice Group. Art, thank you so much for co-hosting today.
It's my pleasure, Nick.
And our special guest today is Gail Bernstein, the General Counsel of the Investment Advisor Association. Gail, you're a returning guest. I really appreciate you joining today, particularly after having just finished your the IAA's annual event. So thank you so much for joining.
Thanks for having me.
And the reason we're getting together is to talk about recent developments in the ongoing litigation over the SEC's private fund advisor rules. So for those of you who might not be following this as closely as the three of us, the SEC finalized this sort of bundle of rules back in August. Very quickly thereafter, in September, an industry group or a group of industry groups filed a petition in the Fifth Circuit Court of Appeals challenging the rule. As a matter of full disclosure, I should say that ICAN and an organization Art is a member of, CalALTs, filed an amicus brief in support of that rule challenge. And then recently, last month, the Fifth Circuit had the hearing on that rule challenge. So we wanted to gather our thoughts in light of that ruling, which obviously a ruling occurs, and then sometime after that, the court issues its opinion. So we're all sort of waiting for the Fifth Circuit to issue its opinion on that rule challenge. But before we get into the litigation, just as a sort of reminder, Art, I know you deal with this on a daily basis with your clients. So these private fund advisor rules, it's sort of our shorthand description of the bundle of rules, did a number of things, and many in the industry were not too pleased about the rules finalized by the SEC. Maybe you can give us a quick recap of sort of the highlights of those rules and why they matter to the industry.
Sure, happy to do that. So you should think of these new rules as having kind of five different components. The first would require private fund advisors to provide very prescriptive quarterly financial statements and information to their investors. Another part would require private funds to get audited, whereas under the SEC's existing custody rule, you have potentially a choice where you could sort of comply with a less expensive option called the surprise exam. There would also be conditions on what we call advisor-led secondary transactions, where you have a fund that is nearing the end of its life, perhaps, and they want to sell sort of some of the remaining assets into a new fund being raised by the advisor. So requirements around requiring some sort of like a fairness, or evaluation of the value that would be required. And then comes a couple of other very burdensome requirements. One is a whole series of restrictions on preferred treatment of investors, right? So funds would be more or less prohibited from providing sort of liquidity preference or information preference to investors if they believe that that those preferences could create a material adverse impact on the fund. And if they did grant them, they'd have to disclose those to all the other investors in the fund. And then finally, there would be restrictions on certain activities that we know the SEC hasn't liked them for a long time, but now they're putting these in a rule, and things like not charging compliance-related expenses to funds, or certain other things with respect to leverage in the fund. And the reason that these matter is because they do impose a lot of burdens on funds from an expense perspective to comply with them, which we know will ultimately be passed along to the investors in the fund. For large funds, maybe it's not as big of a deal. I mean, there are clearly some inconsistencies between the SEC's marketing rule that was adopted, call it a year and a half ago, and the financial statement requirements, and whether or not you can use your quarterly reporting to investors as marketing. So there's a lot of things that have to be worked through with that. So for bigger funds, maybe it's not as huge of a burden, but for smaller funds in particular, and at CalALTs, that's something we're really focused on. For emerging managers, this could really be a killer, right? Just the cost of complying with this, the cost of the fund, it would just reduce the returns to the point where maybe it wouldn't make sense to launch funds. So in a nutshell, that's why we're so interested in seeing what happens with these rules ultimately.
Well, that's a lot. Seems plenty there to complain about to the Fifth Circuit by the industry groups. And I know one of the points we focused on in the amicus brief we did together was some of those prescriptive portions that that the limited partners want to that sort of require certain terms for the limited partnership agreements. Some of the investors don't like these rules either. Some of the fund investors. So that's perhaps an additional reason to not like some of these requirements, but. In any event, the litigation was filed in the Fifth Circuit, as I said, and we did have the hearing last month. Gail, I understand you reviewed some of the hearing, maybe all of the hearing. It went on for some time. It was a spirited discussion among the litigants and the judges. What were your takeaways from the hearing?
I did. I listened to the hearing and I reviewed the transcript more recently. It was a very interesting hearing. You know, as you know, a lot of arguments are made in briefs often that don't make it into the hearing. And I think the hearing really focuses on what, in this case, you know, that the parties want to emphasize or where they think they might need to clarify something. So it's always interesting to sort of see what makes the discussion, what makes the oral argument. So this hearing focused on, you know, as expected, I'd say the bulk of time was spent on whether the SEC has authority under a section that was adopted as part of the Dodd-Frank Act in 2010 that was really designed to make broker-dealers, the standard of conduct for broker-dealers as robust as the fiduciary duty for advisors. And it really has been interpreted as being retail focused. But here the SEC has looked to that provision as authority for this package of rules that that you've been talking about, and that is the subject of this challenge. So the bulk of time was spent on this section, which is 211H, and whether or not it provides the SEC with this authority to go directly at private funds or advisors, and then indirectly through the advisors to regulate private funds. Big takeaway is that the panel of the Fifth Circuit panel seemed skeptical of the SEC's position on this, but the argument went in a somewhat surprising direction in that the panel seemed very interested in potentially saving a couple of the rules, even if it were to decide to vacate others. And it pressed petitioners' counsel on whether it could do that. So the issue here is that, you know, as you've mentioned, the package is 5 rules. It's not one rule. And one could argue that the petitioner's brief only challenges 3 of the 5 rules. And that's the position that the SEC is taking. Petitioners' counsel, of course, insists that all of these rules are part of a unitary whole, and they should be viewed as a single rule. So the question is, if 211H is out, the petitioners say all the rules must fail on that basis. The SEC says even if 211H is out, the rules that were not challenged should survive. Interestingly, you know, the SEC explicitly makes the argument that each rule stands on its own, and you should sever those rules that may not survive and uphold those that can. But I think to me the point that's more interesting is if the court were to find that 211H does not provide authority for the SEC to regulate indirectly private funds, and if it also decides that the petitioners only challenge 3 of the rules, what does it do with respect to the other 2 rules, which were founded on 211H? So if the SEC didn't have authority, doesn't it not have authority for all of them, but potentially 2 of them weren't challenged? Another aside here that I'll mention quickly is that the SEC's rulemakings that have been coming out more recently are clearly focused on being litigation sensitive, let me put it that way. And the SEC now seems to be focusing explicitly in its rule releases on the idea that challenged rules can be severed. If some go down, others can potentially survive. The recent climate rule is a good example of this, where the SEC includes explicit language on this. And I could be wrong, but I don't believe that I've seen that before. 2 other interesting takeaways for me from the hearing are related. One is the other statutory basis for the rules. And I actually think that this is potentially the most interesting part of this litigation. The SEC has broad anti-fraud authority under Section 2064 of the Investment Advisors Act, and it's what's known as prophylactic authority, which means that the SEC can decide that certain things are going to be fraudulent conduct and prohibit them in advance of the fact. So petitioners have challenged this basis as well, arguing that the SEC failed to define the allegedly fraudulent acts in its adopting release, and really doesn't have any justification for adopting these 5 rules as anti-fraud rules. Petitioners also argue, and I read this as a separate argument, but it's connected, that the SEC cites to only a dozen or so settled enforcement cases and says they cannot possibly form the basis for upending a $26 trillion economy. In other words, in addition to the 2064 argument, they argue that the SEC didn't have a factual basis for the rules. Of course, the SEC pushed back, arguing that settled cases reflect the SEC's finding of a violation, and that there's no precedent that an agency cannot consider settled actions. So I think that if the court reaches that issue, it will be extremely interesting. The thread of settled enforcement cases goes through the entirety of the SEC's current rulemaking agenda. It will be a very interesting, it will raise some interesting questions. I was a little bit surprised by how much time was spent on both of these arguments, and in particular, if the court were to question the SEC's prophylactic anti-fraud authority, that could open a massive Pandora's box for the SEC and for all advisors, not just for private fund advisors. It's a provision that the SEC relies on frequently for its rulemaking. And for example, the marketing rule that we mentioned a little earlier, the pay-to-play rule and other rules are based on 2064. So that's a synopsis of what jumped out at me from the hearing. I don't want to speculate about how I think the court will decide, but it was certainly an interesting hearing.
Well, it sounds like, and so we may expect a ruling. It could be any time, I suppose, but it sounds like we'll be watching for the outcome. Of course, the court could vacate one or more of the rules, but also it sounds like we should be looking at the rationale the court uses. On what basis does it vacate some or all of the rules? Or the court could decide for the SEC and not vacate any portion of these rules. So very interesting. Well, since the outcome is uncertain, what are advisors doing? What if the court does throw out all the rules? What happens then? And in the meantime, are advisors going ahead and preparing to implement? What's going on?
Well, the rules are set to go into effect initially in September of this year and then in March of next year. So the court, it's not surprising that there's an expedited schedule before the court. But at the end of the day, if firms wait for a decision, that will not leave a lot of time to get ready. These rules are a heavy lift. The IAA has a private fund rules implementation working group, and it is huge, and we've met several times, and there are a lot of interpretive and operational questions. So, I think ignore this or wait at your peril is what we would say. It's an area, it's a reason why the private fund rules are an area of focus pretty much everywhere you go. Folks are not waiting, and in our view, nor should they. As you said, Nick, litigation is uncertain. There is an argument that even if the SEC loses the court challenge in part or in whole, it will have achieved its goals, because you have to change so much as you move ahead to put things into, to operationalize everything. And so the argument is that if folks begin implementing now and the SEC loses, what do they do? Do they then back away from everything they've done? I generally find this argument fairly persuasive, but I don't find it that persuasive here, because so much of this rule has to do with contract negotiations, with fees and expenses, with obtaining consents, with really including in these mandated quarterly statements very complicated calculations about performance. And my gut on this is that if these rules were vacated, firms may back away from the work that they've done. Not everybody likely will, but I think that there's a pretty good chance that firms will.
Yeah, and I guess to one of Art's points, for the smaller advisors who may have sunk cost into beginning to implement, those will be lost and may hit them harder than the larger advisors perhaps. So that would be unfortunate.
And
Well,
as you know, Nick, I mean, that's a concern of ours for,
yeah,
across the board with all these rules.
that's right. That's right. Well, Gail, thank you so much for joining us. Art, thank you for co-hosting. For the rest of you, please join in for our next episode of SEC Roundup. Until then, goodbye.
Thank you.
Thanks.